section is definition. Definition of a company is formed for any purpose of any common object, while a partnership is formed with the relation of two or more individuals who agreed to share the same amount of profit carried on by all or one acting for all. The second one is law. The law of company is Companies Act 2016, and the law for partnership is Partnerships Act 1961, which revised 1974. The third one is the lifetime. The lifetime of a company is mere abstraction of law, while a partnership is a mere aggregation by individuals. The fourth one is liability. The maximum liability of shareholders in case of limited company is limited to the face value of shares which purchased by them. But a partnership, the liability of the partners is unlimited. The last one is number of members. A private company, the minimum should be 2, the maximum should be 50. A public company, the minimum should be 7, and there is no maximum limit. For the partnership should have a minimum of 2 and a maximum of 20. 9A of Companies Act states that the company shall have a name. This company is named as Panggung Gemilang Sdn Bhd. Section 9B of Companies Act 2016 said the company shall have one or more members having limited or unlimited liability. Panggung Gemilang Sdn Bhd consists of 25 members and is a limited company. Section 9C of Companies Act said that the company shall have, in the case of company limited by shares, one or more shares. The liability of each member of Panggung Gemilang Sdn Bhd is limited to the amount unpaid on shares held by them. The Section 9D of Companies Act says that the company shall have one or more directors. The director of Panggung Gemilang is Per Dinera. This company is Panggung Gemilang Sdn Bhd. According to Section 35, Section 1 of Companies Act, for a private company, the name of a company shall end with the word Sdn Bhd. A company should make sure the availability of a company which the name is available, it is not undesirable or unacceptable, identical to existing companies, corporation or businesses, identical to the name that is being reserved under Companies Act, or the name the kind of minister has directed the registrar not to accept for registration.
Application for incorporations. The first thing we need under Section 14.3 CA Company Act 2016, which is submission of company details. So the first things we have is name of business. So the name of our business is Panggung Gemilang Sdn Bhd. The company status for our company, limited company Sdn Bhd, a private limited company, and also Panggung Gemilang have 25 staff. The nature of a business is our company is a printing service business. And then the need in application form also the business address, office number, fax number, and lastly is email. Next is effects of incorporations. So our company Panggung Gemilang, we have several aspects of incorporations. The first is personal liability protections. So the secondly is tax benefit. Lastly is raising capital.
Characteristic of the company. Panggung Gemilang Sdn Bhd is a private company. Companies whose shares are not listed on the stock exchange market compared to the public company. Our company located in Kuching, Sarawak. Private company established to strengthen the credibility of the business. Share in the private company offered to purchase and sold or trade privately only can be referred under Company Act 2016, Section 11, Subsection 1. Panggung Gemilang Sdn Bhd is a separate legal entity. Is one of the benefits of just doing business with name ending in Sdn Bhd. This has the right and responsibility is on statute separate from operating endorsed entities. Can be referred under Company Act 2016, Section 20, A and B. This means that company is legally treated as a separate person. This company has almost all the power. The privilege of a separate legal entity is our company can buy, sell, and own any property in our own name. In addition, agree to make the contract legally, it can be sued and be sued on behalf using own name. Can be referred under Company Act 2016, Section 21, Subsection 1A. Panggung Gemilang Sdn Bhd asset belong to the company. Can be referred under Company Act 2016, Section 223, Subsection 1A, which can be through specific written expression of the business or real estate only. This means all purchase of the money of the company is the property of the company. Even if there are debt, bankruptcy, illness, changing of membership, or departure from the business of the owner or shareholder, or sale of the share, a perpetual company is a continuation of the life of the business entity. Internal substitution is one of the reasons that explain the existence of the company law as a separate from its shareholder. This shall not affect the company status.
A company constitution is a document that outlines the rules governing the company's internal management. It also summarizes the relationships between parties that are relevant to the companies. We will be looking at the effect of a company's transaction that does not adhere to the constitution. When a company's transaction does not adhere to the constitution, they will be facing difficulties in the processes and the procedures. Moreover, this transaction is known as an ultra-virus transaction under the Companies Act 2016. There are two scenarios where a company constitution can be amended. The first one, looking at Section 36 of Companies Act 2016, a company constitution can be amended by special resolution as long as the constitution itself allows for amendments. The second scenario is where a company's constitution does not allow it to make amendments. Looking at Section 37 of Companies Act 2016, a director or member of the company can make an order for the court to amend it. A public company can choose to have or not to have a constitution. Looking at Section 32 of Companies Act 2016, if a company wishes to have a constitution, they can adopt a constitution in a way of special resolution. However, as stated in Section 38 of Companies Act 2016, a company limited by guarantee is subjected to having a constitution. The first part specifies the introduction and the objects of the company, and then the later part specifies the provision on shares, general meetings, sale, accounts, and alteration of constitution based in our company.
Next, I will continue the presentation by presenting the duties of director and company secretary. The main duty of directors are to use their powers for a proper reason in a good faith in the company's best interest. The director must only consider the interests of the company and no one else, not even his own personal interest. The main duties of a company secretary are to ensuring the company information and details is up to date. Business information such as directors, shareholders, paid up capital, shares, and constitution could change as the company expands from time to time. Next is function of other officer. The first officer is CEO of the company, which is Pearl Yanar Muni. The main duties are making major corporate decisions, overseeing a company overall operation and resources. The second officer is Vice CEO, which is Fitriana binti Widin. The duties are overseeing internal activities and helping to establish good customer relationship. The third officer is Chief Operating Officer, which is Jason Vitos. The COO responsibility is supervising a company everyday administrative and organizational function. The fourth officer is Chief Financial Officer of the company, which is Nur Azurin Shahira binti Zakaria. A CFO duties are in charge of overseeing company financial action. Next, I will proceed the presentation on the question for the company. The first question is how the director of our company can avoid conflict of interest and how they apply good business judgment in decision making. The director of our company can avoid conflict of interest by preventing to be in a situation where there is a possible conflict of interest to be happen. Director can apply good business judgment by always making sure that the decision made is not contradict with the business judgment. The second question is, do good ethical business practice in your company, and how do you encourage your employees to display good ethical business in the company? The two good ethical business practice in our company is integrity and responsibility. To encourage our employee in the company, the upper management of the company should appraise the positive behavior of the worker.